Hi, everyone. I'm Raul Pinto, Senior Staff Attorney with the North Carolina Justice Center. Last Thursday, on July 16th, we had a webinar where we talked about the risk versus the rewards of applying for DACA for the first time in light of the Supreme Court's decision back in June to reinstate the program. Now, at that time, USCIS had not provided any kind of guidance or directions as to whether the agency was going to accept new applications. So the next day, on June 17th, a federal court in Maryland said that the program for DACA had to be reinstated as it was originally established. A lot of people took that to mean that new applications had to be accepted. The one thing that I would say is that while USCIS has to accept applications, it doesn't necessarily mean that they have to approve them, especially without any guidance from the agency itself. So I think the information that you'll find in the webinar still applies, and I'd say be very cautious about applying for the first time, but this does open a new significant benefit because the court says that USCIS should accept the application. It could still very well be that you get a rejection, but now there's a court decision that at least provides some guidance into the topic. So we hope that you find the information useful, that you'll use it in making your decision as to whether you are going to apply or not, and definitely talk to an attorney before doing so. Thank you so much, and I hope you find the information informative.
Hi, everyone. My name is Raul Pinto. I'm staff attorney with the North Carolina Justice Center. Welcome to this, this webinar. I'm going to introduce right away Melissa Morell. She will be our interpreter for the afternoon. Voy a introducirles a Melissa Morell. Ella va a ser nuestra intérprete para el día de hoy y ella va a dar algunas instrucciones para las personas que necesitan la traducción en español. Van a haber también instrucciones en el chat del grupo, así que por favor si también prefieren establecer la interpretación de ese modo, pueden hacerlo. There will be also interpreting instructions on chat, on the group chat, so if you prefer to read those instructions there, you're welcome to do so. But take it away, Melissa.
Hola a todos y todas. Hi, everyone. Just really quick, this is not available until we activate the interpreting, so this is going to just take a minute, but I just want to explain that if you are not bilingual, in just a few minutes you're going to see an option at the bottom if you're on your computer to choose a language, either English or Spanish. If you're on a phone or a tablet, if you look in the chat on the right, in both languages there I have the information on how to find that. If you are having trouble, just go ahead and put a comment in the chat box and we can work with you on that. But if you're not bilingual, you should go ahead and choose a language. This presentation is going to be in English and it'll be interpreted simultaneously into Spanish on the Spanish channel. Entonces, buenas tardes a todos y todas. Vamos a tener interpretación en español. La presentación se va a presentar en inglés y vamos a tener un canal de interpretación en español. Entonces pueden ver las instrucciones en el chat allí de cómo escoger un canal para español si quieren escuchar en español. Todavía no se puede ver en este momento hasta que activamos la interpretación. Si tengan en algún momento algún problema, pueden poner su comentario en el chat. También si alguien que habla español, si tenga pregunta, se puede poner en chat en español y nosotros podemos traducirlo y hacer la pregunta cuando tengamos los momentos de preguntas. ¿Okay? Entonces vamos a activarlo. Y van a ver ahí abajo su lugar donde pueden escoger.
Hello everyone, my name is Juan Calderon. Thank you for joining us today. I'm a paralegal for the Immigrant and Refugee Rights Project at the North Carolina Justice Center. For those of you who don't know much about the Justice Center, we are a progressive research, legal, and advocacy organization located in Raleigh. At the Justice Center, we are committed in the fight to eliminate poverty in the state by providing our services to people of low income from all over the state. The Immigrant and Refugee Rights Project, of which I'm part of, focuses on community education, grassroots organizing, and providing free legal immigration services for high-impact cases. Raul is our senior immigration attorney for the project, and he's mainly involved with legal advocacy, community education, and litigation in immigration court. Now I turn it over to Raul.
Thank you, Juan. Thank you, everyone, like I said, for joining the call today. This is mostly to give folks information and to really try to weigh in as to what the risks are going to be for new applicants or DACA who may want to apply for DACA for the first time. With me today is also our special guest, Kara Lancaster. She is an attorney with Ogletree, Deakins, Nash, Smoke, and Stewart. And she'll be talking a little bit about how people with DACA may be eligible for employer visas. And we'll get to her part of the presentation a little bit later on. But really the goal is to provide you all with information so that you can make the right decision when it comes to your case. As Juan said, our main goal within the Justice Center, one of our main goals of the Justice Center, is to work on community education. We value that goal, that task, and therefore we think that this is very important to get as much information to the directly impacted community as possible. So really the training is for today is going to be for impacted individuals, as well as with allies who can then pass on that information to impacted individuals. So with that said and all the instructions out of the way, let's get started. See if I can do this slide presentation and to keep going. So basically what we wanted to discuss from the very get-go was what did the Supreme Court decision say? And basically what the Supreme Court said is the Trump administration violated what's called the Administrative Procedures Act, which is a federal law that gives guidance to agencies as to how they are supposed to provide benefits for individuals whenever that happens. And so terminating a benefit would require a specific process. And what the court said is that the Trump administration did not follow that correct process when it ended DACA. So keep that first bullet in mind, and because the second bullet is very important, and it's going to actually feed us into that last bullet point, which also means that the Trump administration can try to end DACA once again if it's done correctly. And we'll talk a little bit about what's been going on within even the last couple of days. Now, what that also means is that the DACA program should, and I put should in quotations in the presentation as you may be looking at it now, should is in quotations because it should be restored to its original state, meaning that the program should be available for people who are applying for the first time. It should continue to apply for renewals. It should even apply for travel permits and through advanced parole. But please don't leave the presentation with just that information because it's going to be very intricate and delicate as to whether you apply. So don't leave, stay on this presentation. We'll talk about those details and the risks versus the reward, but that's really what the program, what it should be happening, right? And so the question then becomes is whether someone who would be eligible to apply for DACA for the first time should be applying. And that's why that word there is highlighted. It's so important. It's the word should. So one of the things that I did want to share with you, and it's interpreted, it's translated here at the bottom, was the statement by USCIS. And USCIS, just to get into a little bit of the specifics, because Kara and myself may throw the name of agencies out there that may not be known to everyone. So I do want to make sure that I am covering those terms. USCIS is U.S. Citizenship and Immigration Services. So when we use that acronym, we'll be talking about the agency, And at bottom, it is the agency that makes the decision on DACA applications. It also does a host of other tasks and makes decisions on a host of other types of applications like U visas, for example. But in this particular case, they are important because they make the decisions on DACA. So when people were applying for DACA, either for an initial application or a renewal, people would be sending their applications to USCIS. So that's what we mean. So we were looking for guidance from USCIS. We were looking for directions from USCIS as to what they were going to do with those original applications. Meaning, if someone was applying for the first time, and after the Supreme Court decision, because remember that the Supreme Court decision should have reinstated the program, we were looking for directions from them as to what they were going to do. Now, oftentimes USCIS, once they get an application, it's not necessarily an attorney, a lawyer, that receives the application and makes the decision. Rather, it goes through someone who just reviews it, who making a determination whether all of the evidence is there to approve it. And so really, those folks that work in that sort of frontline desk, if you want to call it that, those folks are the ones that need really the direction from the agency to see what are we going to do with these types of applications. So just about the day after the decision, if not the day of the decision came out, USCIS basically published a statement. It basically said that they disagreed with the Supreme Court decision. And if you read the statement, it just says that the court's opinion has no basis in the law. And to many attorneys across the country, that seemed a little bit ridiculous, because obviously the Supreme Court is the entity in the United States that makes a decision whether something adheres to the law or not. And so that, though, was a very strong signal that USCIS was really not going to publish guidance, about how the program would continue. And so then we started getting some other statements from the administration that muddled the waters as well, made it less clear for us to figure out what the agency was going to do. And you have to remember that USCIS is a sub-agency of the Department of Homeland Security, meaning that they work under the direction of whoever the Secretary of Department of Homeland Security is, and obviously the Department of Homeland Security works under President Trump. One of the reminders, actually, just as far as logistics are concerned, we are going to have some question and answer. So if you have a question about what we're talking about, make sure to type it in the chat. We won't be answering sort of case-specific questions, meaning that if you type in the chat, I have this situation, we may not answer your specific question, but we also see some general trends on questions, and so we may answer questions about a general topic rather than a specific situation. So please, put your questions down in the chat box, and Juan and our project director, Denny Moore, will be monitoring the chat, and we'll be asking those questions at the end of the presentation, okay? So we move on then to what did President Trump say. And we were very aware of the tweets that he sent out. And if you read the ones that appear on the screen on the left, and for those folks on the phone, I'll read them out. It says, the Supreme Court asked us to resubmit on DACA. Nothing was lost or won. They punted, much like in a football game, where hopefully they would stand for the great American flag. We will be submitting enhanced paper shortly in order to properly fulfill the Supreme Court's ruling and request of yesterday. I have wanted to take care of DACA recipients better than the do-nothing Democrats, but for 2 years they refused to negotiate. They have abandoned DACA. Based on the decision, the Dems can't make DACA citizens. They gain nothing. So, but really the key sentence there, the key phrase in that tweet is basically that they would be resubmitting on DACA. And so that led us to believe that they are more interested in ending DACA once again in a legal way, supposedly, than actually providing guidance as to how they will retake the the acceptance of applications. Now, if you look on the right, that tweet is by the acting Deputy Secretary of Department of Homeland Security, Ken Cuccinelli, who basically said that they were going to redo the ending memorandum. So the memorandum that ended the program of DACA, they were going to redo it and resubmit it. So we've been hearing for the last couple of weeks that the Department of Homeland Security is going to write a different memo that will end the program. So again, all of that leads us to believe that they are not going to accept new applications. Rather, they're going to be redoubling their efforts to end the program in quote unquote the right way, even though we're not really sure as to what that looks like. Now, it could be that they issue a new memorandum, and that memorandum also is subject to a lawsuit, which could delay the termination once again of the program. So we have to be very cognizant of what is happening with the program, happening with the courts. That is going to give us some more direct guidance as to whether new applications will be accepted or not. So what does this mean for people in North Carolina? People who have DACA in North Carolina obviously can continue to renew it. As far as we know, that has not stopped. People who are applying for renewals, they have been getting them. And as a matter of fact, they've been getting them relatively quickly. So our office about 2 weeks ago or so, maybe 3 weeks ago, sent a DACA application into USCIS right before the decision came out, and it was approved in about a week or so. So we're seeing very fast turnaround times on those applications, okay? That then also means that DACA recipients in North Carolina can renew their driver's licenses. So if you look at the right-hand side, that's an examples of how the DACA license looks in North Carolina. So if you have DACA, that is how your license looks. If you see that it says legal presence, no lawful status, and that is just correct legalese language. It's just very legally correct language. Unfortunately, it's there, which kind of marks you as a DACA recipient, unfortunately. But that is what it says. And the last point here is reviewing something that I mentioned before, is we have to be on the lookout for a new attempt for the administration to end the DACA program. So if you do have DACA and you need to renew, again, do it sooner rather than later. There could be delays because USCIS is actually experiencing some budgetary shortages. And so there could be some delays after this decision. We also know that if you file ahead of time, you're buying yourself some additional time if the program is ended. So that is something also to keep in mind. Okay, so what about new DACA applications? Very important, really that's the $1 million question, and we're going to talk in detail about that. I thought that it would be a very good idea to review the eligibility requirements, because remember, DACA was not available for everyone, right? You have to have met some very strict criteria, and this strict criteria also continues to apply. This basically means that folks, the window of people that are eligible for this type of relief is shrinking. Because if you look at the age category in the first point there, in the first requirement, that's what's keeping people out of DACA, right? So you need to have been under the age of 31 as of June 15th, 2012. You had to have been in the US before 16 years old. And then you have to have continuous presence in the US since June 15th of 2007. You have to have been present in the US on that date, on June 15th of 2012, and at the time of applying, and also have had no lawful status on that date. So for example, if you entered the United States with a tourist visa, but you overstayed that visa, right? And you had that tourist visa at that time, then unfortunately you did not qualify for that original DACA, and you wouldn't qualify for it now. We have to be very careful about these requirements. The sixth is the educational requirement, which also could get a little more stringent, and we'll talk about that. But in the Obama administration, when the program was first announced and then expanded just a bit, there were different educational requirements or educational programs that could have fulfilled this requirement. So obviously, if you were still in high school, that made you qualify for DACA. If you were in some kind of college, or even getting your GED was qualified you for DACA. There were even programs like ESL programs that qualified you for DACA. Different types of educational ways to meet that requirement. But there was also a disqualification, which did disqualify a lot of folks for certain crimes. And we know, for example, that DUI was what's called a significant misdemeanor. If you had a significant misdemeanor, you would be disqualified. If you had 3 misdemeanors, and these were convictions, by the way. So if you were convicted of 3 misdemeanors, then you would be disqualified. If you were convicted of a felony, then you would be disqualified. And unfortunately, the DUI crimes, for example, of domestic violence, did disqualify some folks. So those were the original requirements. And again, I want to highlight that these need to be met now as well. If anyone is thinking about applying for DACA for the first time. So should I apply for the initial DACA? And the first point remains true, and this is what I want you all who are thinking about applying, who are in contact with folks who may be applying for the first time, that I want you all to know that right now USCIS has not provided directions as to how it's going to accept these types of applications. And as a matter of fact, we have been hearing now from listservs. So when the decision first came out, there were some attorneys and some more nonprofit organizations who advised their clients to go ahead and apply if they had first-time applicants, okay? For several reasons, and that, it really depends, and we'll talk about that in a little bit as to what those reasons may be. But really, folks started applying because, again, the Supreme Court, one of the things the Supreme Court said was that the program, that the effect of the decision was that the program should be reinstated, right? But without any direction, again, those frontline officers don't really know what to do. So now we're hearing via emails from different immigration attorneys who submitted these types of applications that the applications are being rejected. Because again, USCIS has not provided that guidance. So what I anticipate will happen, and we'll go through what the possibilities are here, but it goes through the first ones. And you really have to know what your risks are here. You really have to know what you're putting yourself through if you file an application. So the first possibility, if you file a new application, is you have the rejection of the application. And to be perfectly honest, I think that would be sort of, other than obviously being accepted and being granted DACA, right? That would be the best case scenario, because that means that USCIS takes the application and says, this benefit is not something that we're doing right now, and it just kicks the application back. And if you remember, DACA applications cost $495, so it had a significant cost, and there was a proposed rule that would actually make them more expensive. So you have to be very careful about that, because the second scenario here would be a denial of the application. Basically, that USCIS would take the application and accept it, meaning that they would actually read it and go through it, but then deny it, which also means that all of the information that was included in that application, whether you had a prior removal order, whether you had one crime that could make you inadmissible, but no other, one crime that would make you ineligible, but no other crimes, because the forms were asking that, right? Then USCIS would have that information. And once USCIS has that information, it can do a whole lot of things with it. The denial of application would also mean that your fee would not be returned, okay? It would mean that USCIS would basically keep your money. And obviously, for some folks who may have 2 children who are of age or DACA, they would be keeping about $1,000. And so that is the big risk. Now, the other risk, and one of the things that I usually tell my clients when they're thinking about doing any benefit, applying for any benefit with USCIS is, you know, if this thing gets denied, there's always a risk that ICE could take some enforcement mechanisms or enforce immigration law against you. And specifically, after a memorandum was issued about a couple of years ago, where ICE said if someone is applying for a benefit and that benefit is denied, then we are within our authority to start removal proceedings against that person. And so that is really what is at bottom here, because what you are saying to USCIS is that if you're applying for DACA for the first time, that you basically don't have status in this country. And if you don't have status in this country, unfortunately, that means that ICE can enforce the law. And so that is always a risky proposition, right? And so that's why I think it is very, very important that you have these risks in mind if you are looking to apply. The last bullet point is basically you lost your filing fee if denied, and that's something that we talked about before. So one of the things about that we could see, like let's say for example that USCIS does accept the applications without guidance and without having that guidance, we could have rejections due to incomplete answers. We're seeing this problem with U visa applications and asylum applications, where if you don't fill every box with something, then it's rejected for those reasons. We could see delays in processing of the applications. Basically means that USCIS just holds the application and considers them for a very long time, or at least until they get some other type of guidance from the administration, and whether that's more guidance on accepting the applications or on whether they would be subject to a different termination. That can also happen. So delays in processing. And the other issue is these strict evidentiary requirements. So we know that there are very strict requirements here to apply. And where it gets tricky is the continuous presence in the United States. So right now, obviously, we're in July 2020. You actually have to provide documents that you have been in the United States since June 15th of 2007. So that's 13 years that you have to document that you've been in the country. And if you can't prove that, then most likely you can have a denial of the application. So what I would say is that if you can't meet those requirements strictly, if you can't show that, then that's going to be a very high risk application. Okay. So actually, before I go on though, one of the benefits of actually applying for it is that one of the strategies that was being talked about was if someone were to apply for DACA initially and not get it, meaning that this application was rejected, you actually get a paper from USCIS saying your application has been rejected. A lot of attorneys are saying that they are developing a legal strategy to have folks who have applied sue the federal government in case that the government should be accepting these applications now. And so at the very least, that also gives you that paper, so that if there is a lawsuit that would cover everyone, you would have that proof that you at least tried to file that application. Again, I think that it's something that has to be weighed with hopefully an attorney before you submit that application. I would not advise a person to do it on their own. So what about advanced parole? And we are getting a lot of questions, advanced parole. Again, advanced parole because, and for those of you who may not know, advanced parole is the permit to re-enter the United States once you had DACA if you travel abroad. But advanced parole was being given by USCIS. Again, it's one of these other benefits that is given by USCIS. And it was being granted for very specific reasons, and they were family-related or humanitarian, business, or school. Those were the three sort of scenarios. Again, it should be restored because advanced parole was part of that original program. But it carries obviously the same risks as an initial application. Right now, decisions to grant advanced parole are taking about 5 months. So you'd be subject and wouldn't be able to travel until you get that decision. Most likely, if you try to file something now, it could be rejected. Again, you'd lose out the money if it's actually accepted and then denied. But advanced parole carries this very specific risk, and I want folks that are thinking about applying to advanced parole to be very cognizant, very aware of it, right? If, for example, you apply for advanced parole and for whatever reason the advanced parole is granted, right? You are risking that if you travel outside the United States on your advanced parole, that if the program is then terminated while you are out, then it falls onto the discretion of the officers at the border to let you back in. And because the program has been terminated, there is a high risk probability that you would not be allowed in because, again, the program has been terminated. So the authority to let you back in would no longer be valid. It's always the discretion of those officers. So just to summarize here, I think you all can see some of the risks, but also sort of the rewards of possibly applying. And we all know the reward of applying for DACA, right? It's basically getting your work permit, your social security card, being able to provide for your families. But you all have to know that it is risky and that there are some consequences that could that could impact your lives going forward with these applications. I don't want to sound like I'm advising not to do it, but I think the overall message is really seek advice of an attorney, go through your own situation, and definitely, and the other thing is definitely talk to immigration attorneys about the eligibility for permanent status. And I think that is really the key point. And that's one of the reasons why now I'm going to hand it over to my colleague, Kara Lancaster, because one of the questions that I usually get at the Justice Center and when I'm doing these types of presentations, DACA recipients have been here for a very long time. When I say here, I mean in the United States. And a lot of them have been working for big corporations for a while now. They've also been working for, mom and pop shops, as they say, or smaller corporations in different types of roles, restaurants, construction. And so one of the questions that I always get, and I'm very glad that Kara is here, is how do I get a visa? If my employer agrees with DACA and wants to help me and wants me to stay in my job, how do I stay in the country? How do I take advantage of that opportunity? So Kara has been an immigration lawyer with Ogletree Deakins, as I said, and she assists businesses and corporations obtaining employment visas, working with L1s and intercompany with transferees. She's earned her bachelor's degree from East Carolina, so she knows this area very well, and her lawyer degree, as we say, or her Juris Doctor from New York Law School. So thank you so much, Kara, for being here. I'll hand it over to you.
Thanks. So, hey, everybody. I'm Kara Lancaster. As was mentioned, I work at a law firm here in Raleigh that focuses on employment-based immigration. And so even though that's really where, I specialize is business immigration, I have also similarly heard the question several times, if I'm on DACA and my employer is willing to sponsor me for a visa or for a green card, how does that work? And so I'm just going to talk about a few of these options that some of you on this call might be able to benefit from. And I'm going to start with the PERM green card process, primarily because I personally do think this is potentially the best employment-based option for somebody on DACA as opposed to a temporary visa, but I'll talk about a couple of temporary visas as well. So first and foremost, with a PERM green card process, it has to be sponsored by an employer. So if you have a job at a company, whether it's a small company or a big company, as long as your employer is willing to sponsor you, that's the first key to being able to start this process. And when we say sponsorship, what we also mean by that is they are legally required to pay the costs of the first step of the process. So you can see the 3 stages listed there. And stage 1 being the PERM labor certification employers have to pay those costs. They are not allowed to even let you pay that cost if they wanted to. Now, they can have you pay for stage 2 and stage 3, or they could pay for it. That can go either way. But they are really responsible for stage 1. And actually, legally, the person holding the role, in this case, in this scenario, the individual holding DACA, is actually not really supposed to be very directly involved in that step of the process. So that's what we mean by sponsored by an employer. They have to be willing, and once you have that, you've kind of completed the first step. Once you have that employer that's willing to sponsor you, the PERM process really just is referring to a labor market test, where they have to show the Department of Labor that they could not locate a qualified U.S. worker for the role that you currently hold. And so when we say labor market test, we really just mean a recruitment effort. They'll post advertisements for the role in the local newspaper. They'll post it on a state job site where individuals can look for jobs. And basically, as individuals apply for the job that you currently hold, the company will receive those applications. They'll have to look through them and screen them and determine, is this applicant qualified for the position or not? If they don't locate a qualified U.S. worker, and that does mean, only if it's somebody that is a U.S. worker. So if somebody applied for the job, but they also required sponsorship, those individuals do not have to be considered as part of this recruitment effort. But if they can say at the end of it that they did not find a qualified U.S. worker, they can then file your PERM application with the Department of Labor. And that at that point, you've kind of done the hard part of this, really. The Department of Labor will just process that application and certify it for the most part. They can issue what's known as an audit, where they just want to see proof that the company did recruit for the role. But it's usually you've kind of gotten past the difficult part by then. So then, stage 2 after the PERM is the I-140 immigrant petition. That's much simpler. It's where your employer basically shows USCIS, the agency that Raul mentioned, they show them that you qualify for the role. So you would present your education documents if you're in a position that has an education requirement. If not, let's say the job just requires a certain type of skill set, you would show that you have that skill set. And that normally means getting letters either from a prior employer or a prior supervisor, possibly even just a coworker who's willing to sign a letter saying this person did work there, this is the type of work they were doing, and here's the skills that they gained. So that's what would be submitted at that stage 2. And USCIS would then approve that application based on, again, the employer has filed it, they've shown that you qualify for the role, and it's generally pretty straightforward. Stage 3 is the I-45 or consular processing. Some of you might already be familiar with this stage because it's no different at this point than other green card processes that might be family-based. No matter whether somebody applies for a green card through a family member or through an employer, they will end up at this stage, stage 3. So what I'm talking about is really just a different way of getting there. If perhaps you don't have a family-based path, or maybe you do, but this could potentially, maybe even be a better option. So I'll talk a little bit more about this on another slide, but these are the 3 main stages. And like I said, it starts with just having an employer that's willing to sponsor you. Okay, so to talk a little bit about the different categories that we see in an employment-based green card process, they're kind of these 4 right here. This isn't, it's the large majority of them. So an EB3 skilled worker is referring to a role that requires at least 2 years of experience or training or more. So when we talk about this category, we're talking about maybe a chef or a construction supervisor, or a graphic designer, or maybe somebody that works in IT support. Next to that is EB3 unskilled, which is also just referred to as the other workers category. This is if the position requires less than 2 years of experience. So a nanny, somebody that works in landscaping or gardening, a housekeeper, even agricultural farm workers. This is that category. And then the other two are for professionals, meaning that at least a bachelor's degree is required with some level of experience typically as well. So EB3 professional would be bachelor's degree and up to 4 years of experience. And in that last category, EB2 professional is bachelor's degree with 5 years of experience, or potentially even if it has a master's degree requirement. So you've got a really big range here, but ultimately the category depends on what the physician's education and experience requirements are. The thing to note that's really most important on this slide is that for all categories, your PERM case is going to be stronger if you can highlight the certain special skills that are required for the job that you also possessed when you were hired into that job. For example, perhaps if you worked as a chef, then you have experience working with a particular, type of food or a type of cuisine or a type of restaurant. If somebody was a farm worker, perhaps they have experience with specific agricultural tools or specific crops. Things like that can still be helpful in this process. And then, as was mentioned, sometimes individuals holding DACA might be working at a bigger corporation. They might be holding a role like a software developer. In that case, you would want to be highlighting what are the required, programming skills that you have that are also relevant to the role. So whatever the case may be, no matter sort of what category the role falls into, it's really helpful to be able to pinpoint what are the special skills that I possess and that were required for this position. Okay, so here is the visa bulletin. Some of you, again, might be familiar with this already. If you have any exposure to the family-based process, there's a similar visa bulletin posted every month for family-based green cards. This is actually the July 2020 visa bulletin for employment-based green card processing. Depending on your green card category, whether it falls into EB2, EB3, or which EB3 category that we just talked about, as well as your country of birth, that will determine whether or not you have a wait time before you can move on to the last step of the process. So I've highlighted here just an example. If you know that your PERM was an EB3, employment-based third category case, and you are born in Guatemala, you would cross-reference those two on the chart, and you can see that the date listed there is April 15th, 2018. That means that only individuals whose PERM application was filed on that date or earlier are eligible to move on to stage 3, meaning the I-485 adjustment of status or consular processing at an embassy overseas. So, you can look at this and kind of see it's possible that you could have a wait time of several years in between stage 2 and 3. Okay, so again, I mentioned I would talk a little bit more about that last stage, which again is the most important one, because the PERM and the I-140, again, those are just a different route to the same end that you're looking for. And unfortunately, a PERM being certified and even an I-140 being approved does not hand you any particular status in the United States. You need to get to this last step in order to have status. So it can really go two different ways, again, as is the case with anybody who gets to this phase of the green card process. The I-485 is an application where you request to have your status changed to permanent resident inside the United States. This is only an option if the applicant entered the United States initially with a valid visa and has not accrued more than 180 days of unlawful presence. To put it a different way, if somebody holding DACA initially entered with a valid visa and essentially by around 18 and a half years old, you know, had applied for DACA, you might be eligible for this option where you can receive your green card inside the United States without having to travel. The other option would be consular processing overseas, where you do apply for an immigrant visa at an embassy or consulate. Obviously, there are separate challenges to that for anybody holding DACA. Departing the United States is something that you definitely want to talk to an immigration attorney about. And really, these two options, I would recommend thinking about and talking about with an immigration attorney before even starting a PERM process, because at the end of the day, this is where you'll find yourself, even if steps 1 and 2 are completely smooth and successful. And this is an analysis that you'll have to do one way or another. All right, and lastly, I did just want to talk about a couple of employment-based temporary visa options. Again, I personally think that that green card process is potentially the better option for somebody holding DACA, but we do get questions, you know, about temporary visas as well. So there's the H-1B visa for specialty occupation roles. And again, that a specialty occupation really just means a role that typically requires a bachelor's degree for entry into that position. There's also a TN visa for nationals of Mexico. But there's limitations to these. Number one, they are temporary in nature. So this is not a permanent solution. The H-1 visa can give you up to 6 years of time in that status, although it can be extended beyond that 6 years if you meet certain employment-based green card milestones. But overall, it's still a temporary fix. And the TN visa, while it doesn't have a particular limit on how long you can hold it or how long you can renew it, there is a law that says you're only supposed to hold this visa if you have a temporary intent to be in the United States. So more than likely, if you're holding DACA, that's going to be hard to show that you have a temporary intent to be in the United States. As I mentioned, these visas are generally only available for professional roles where at least a bachelor's degree or several years of experience are required for the position. And then both of them, in order for you to hold this status, you would ultimately have to activate it at a U.S. consulate or embassy overseas via consular processing, similar to the stage 3 option with the green card process, where you might have to depart the United States. It carries a lot of the same risks of having to balance sort of, do I need a waiver before I leave? How am I going to get back in? Is there a risk that something could happen while I'm outside? So again, always best practice to speak with an immigration attorney who can help you sort through those issues. And I think that's it for me. I hope that was helpful. And hopefully if any of you feel that this does fit your situation with your particular job or your particular employer, it's definitely something that I think could be beneficial for individuals holding DACA.
Kara, so thank you so much for your presentation. And if you don't mind sticking around and for the question and answer, again, if you have a question, we may not be able to answer your specific case question, but we would be able to answer sort of issue-based questions. So please type in your questions in the chat box of the presentation, and we'll try to get us to as many topics as possible. Within my last 5 minutes or so, and hopefully folks, we want to just keep it to an hour or so, but we'll stay a little longer to get to the questions part, because I do want to make sure that folks know what is at stake and how they and we can really talk more about a permanent solution for DACA recipients. Basically, we have a lot of data. The Justice Center works with the Budget and Tax Center in North Carolina, and they have done a lot of research relating to the economic benefits of DACA recipients. We know that they help North Carolina as a whole. Their educational attainment increases wages for everyone, and DACA provides critical connections to the formal economy, supporting the wages and strength for all workers. And the reason why I wanted to highlight these is because we wanted to basically give you all tools that if you are visiting a senator or a representative or your representative and advocating for DACA recipients, that you have some of this material in hand. By the numbers, 24,000 DACA recipients in North Carolina. This was not a North Carolina number, but I thought it was very interesting that 256,000 have US-born children with DACA parents. And so we see the impact that this is having on families, not just that individual. 19.5 million in mortgage rental payments in Charlotte made by DACA holders. 17.8 million in mortgage and rental payments in Raleigh made by DACA holders. And that's one particular industry. $58.6 million estimated amount paid in state and local taxes by DACA recipients. And that figure includes DACA eligible individuals in 2018. So we see the benefits of continuing with the program the way that it was intended. So again, I wanted to touch base really quickly about what's right now in the Senate, what is right now in the House of Representatives, so people can really advocate for these more permanent reliefs. Right now, the one that most folks are supporting is the American Dream and Promise Act. It has passed the House of Representatives. So all it would need is a vote in the Senate and then a signature by the president. And it would actually cover DACA recipients and TPS, because if you remember, the Trump administration had announced that it would also end TPS, temporary protected status, for folks from Honduras, El Salvador, Haiti. And so it's really expansive. So it applies and helps a lot of people. It's not strict to DACA recipients. It does contain a pathway to citizenship, which is also very good, because we know that the continuity of these folks within our economy, it enriches our communities. So we want a bill that will have that aspect of it. Special considerations. It covers people who arrived 4 years before the enactment of the law. So it actually is a little broader also than the program of DACA itself. So we wouldn't be looking at the DACA requirements anymore. We would be looking at the requirements of this particular law. The RAC Act actually and the Bridge Act are teetering right now. Those were more restrictive. And so they're unlikely to pass right now, because I think there's just, it's just a matter of where they are in the process. As a matter of fact, I think that the RAC Act, if I'm not mistaken, has actually not been pushed forward. But again, sort of they are general fixes for the DACA program. If you take a look, for example, at the Bridge Act, there's no pathway to citizenship. And so, that could obviously be very problematic, because we could be here, even though this would be a congressional act that would provide some kind of higher level of protection, it wouldn't provide any additional protection. Basically, it would not grant folks who have DACA right now the legal permanent resident status. And the last one that I want to note, the last one that I wanted to note is the one that has been proposed by Senator Tillis, which is the Succeed Act. And the Succeed Act is very interesting because it does provide a pathway to citizenship, but it's very restrictive. If you take a look at who would be included, it'd be people with prior orders of removal. And we know that DACA, if you had a prior order of removal, that DACA would still cover you. People who are inadmissible or deportable. So basically, if you have committed, crime of moral turpitude, and that's a very specific immigration term, but it could range from anywhere from shoplifting to domestic violence. Sometimes those crimes could be crimes of moral turpitude. You would be excluded from this benefit. And it does cover a pathway to citizenship, but there are other limitations. For example, that if you become a legal permanent resident through this law, you then wouldn't be able to petition or ask for a visa for your loved ones. And obviously that could be very limiting for folks with families in the United States. Again, the reason why I wanted to highlight this is because I want people to know that when they say, I support Dreamers, I mean, Senator Tom Tillis could also say, I support Dreamers, but you have to look at exactly the specific details of what he is proposing. Requires individuals who lost status due to crime to agree to expedited removal. Expedited removal, again, is a very specific immigration term, but what that means is that you would not get to see a judge before you are actually deported, that you would actually be deported right away. And so that is obviously problematic. And we're seeing right now how these bills are progressing. And I guess the last thing that I could share just within the last couple of minutes is that the Trump administration yesterday, a couple of days ago, I think 4 days ago, in an interview with Telemundo, said that he was going to sign an executive order granting DACA recipients a pathway to citizenship. And I believe Senator Ted Cruz immediately said, that's not possible. You can't do that. And for once, I mean, I actually kind of agree with Senator Ted Cruz. He cannot do that through executive order. It would be very hard to pass through, not only to pass through Congress, but just how the immigration system is actually set up. That would be very difficult. We really right now don't know exactly what the Trump administration has in mind and how that is going to protect the DACA community. Because the other thing he said is that he wants a merit-based immigration system. And what that could mean is something like what Kara was saying, right? Where, for example, the people with higher degrees are given priority within the system, if not preference over anyone else. And so if there is some kind of DACA protection in a bill that provides this sort of turning around of the immigration system, that can also be bad. And right now, there are very limited bills. Actually, I don't think there are any bills that have passed either chamber, meaning either the House or the Senate, that would actually do this. There was one introduced, but none of them have passed. And so we're waiting to see what the Trump administration actually meant when President Trump announced that he was going to provide protection for Dreamers. We just don't know. And as a matter of fact, there's been rumors that there's going to be an end to DACA. There's been also rumors going around that actually the Department of Homeland Security even does not know what he has in mind. So keep an eye on the news. As Kara and I said before, talk to an immigration attorney before you embark in any process, and specifically if you're applying for DACA for the first time. With that said, I'm going to open it up. I think my colleagues with the Justice Center, Danny Moore and Juan Calderon, have been monitoring your questions. So hopefully we have a couple of good ones that Kara and I can tackle.
I think we're going to start with Juan Calderon offering a question. If you are joined on a computer, you'll find the chat window either at the top or bottom of your screen. And if you are joined on a phone or something like an iPad or tablet, I think you'll have to click the 3 dots that say More in order to select the chat window and add your questions there. I'll turn it over to Juan. Thank you.
I don't know if Kara or Raul can answer this question. If the applicant has accrued unlawful presence or is subject to any other grounds of inadmissibility, does he or she need to apply for a waiver of those grounds under the PERM process during the final stage after departing the U.S. for consular process?
So the question was if you have any unlawful presence?
Yeah, or any other grounds.
So if you have less than 180 days of unlawful presence, you can apply for that last step inside the United States, the I-485. Grounds outside of that would have to sort of just be analyze case by case. I do know if anything in that assessment leads you to the conclusion of, okay, I can't apply for I-45, I have to do consular processing, that's when you maybe would need to get a waiver before departing the United States. I don't have as much expertise probably as Raul has in that area, but I do know that's something that some people have to consider.
Yeah, and I'll add sort of how it would work in a family-based petition. So let's say, for example, that you're the husband of a U.S. citizen or the wife of a U.S. citizen. Then yeah, you'd have to take a look at what ground of inadmissibility applies to see if a waiver is even possible. So for example, if you've ever said that you are a U.S. citizen in a form, that could be fatal to an application as far as the family-based petitions are concerned. But for example, if you've been undocumented for more than a year, that's something that could that could possibly be waived depending on the circumstances of the case. So it really does depend, and that's why it's so important to talk to an immigration attorney, and specifically for DACA folks, because DACA folks, remember, some folks got it at the age of 15. You had to be 15 to apply for DACA. And so they've never accrued, and if you've been renewing periodically, you've never really accrued unlawful presence. So you may actually not have that problem. It gets a little tricky if you've let it lapse, right? If you, for example, let DACA lapse, or if there are gaps within your applications, then that could be problematic and could pose obstacles down the road.
Thank you for this informative presentation. One other question is, should people who have active DACA right now renew as soon as possible, given all the uncertainty about the future of the program?
That is a very, very good question. And I'd say it depends on, I'm going to give you the lawyer answer. It depends. It really depends on this specific situation, right? Because if you, for example, if your DACA expires within the next 5 months, then I'd say, yeah, go ahead and renew, because it could take that long to get you a decision, specifically given how things are moving. It can give you about 1.5 years extra of protection, because remember, they're 2-year periods. And so, but if you have 1.5 years of protection, then maybe it can get a little more difficult to make that assessment, because at the end of the day, you're only going to be buying a couple of months, meaning that you're going to be paying for the renewal to just give you a couple of extra months to renew. So it really depends on how long. We were fearful that the Supreme Court was going to end the program, to be perfectly honest. And so I was very surprised by the Supreme Court decision. And if the program were to end again, it could very well terminate people who have, who had those renewal pendings. They could terminate it as of right, but as of right now. So, it really depends on the situation as to whether you renew right away or not. Danny or Juan, are there any other questions in the chat that we haven't answered?
No more questions. No one has posted any questions.
Okay.
I do have one more question, and then we can wrap up. You mentioned that there are a lot of rumors going around, and perhaps the role of Congress in deciding the future of the DACA program. But when do you think we'll all know more about the future of DACA? For example, what's the role of the November election and the lower courts and the Supreme Court going forward?
That's, again, a very good question as well. Obviously, with a new administration, there could come new rules. And so obviously the November election is extremely important. Not only because you're choosing who is going to be the president and therefore who is the head of Department of Homeland Security and the agencies making these decisions, but because you can possibly have a turnaround in the Senate that could be more friendly to a permanent DACA solution. And I think that is extremely important, right? If we want to get something passed in the Senate, I think we're going to need a change. And so I think that's why these elections are extremely important, and also sort of the court, right? As I mentioned near the beginning of the presentation, is that if the Trump administration issues a memorandum that terminates DACA once again, then it very well could be that there's a lawsuit over it again. And so we would wait to see what the courts do. I mean, remember that the continuation of renewals, but the stop of initial applications and advanced parole, that was a system that was devised by a court. That was a system that was devised by a district court. And so we have to be very, very aware of what the courts are doing and what they could do with a new order to terminate the program. And my expectation would be that a new termination would also end up in court. I'm not certain, but it can very well end up in court, and we can see what the program looks like after that court decision. Any other questions sort of in that while we answered those queries?
There's one question, Raul.
Yeah.
It says, what will happen if DACA ends and you are a DACA parent?
Well, I guess the way that I would answer that question is to say that, unfortunately, if DACA was to end and the DACA termination is upheld by the courts and it has gone through the entire process, my expectation would be that folks would revert back to their original status, to the status that they had before getting DACA, which then means that it's usually would be undocumented. Unfortunately, that would be the way that that would work out, right? But that's why I think it's so important, and that's why I think, talking to attorneys like Kara and other folks who are doing this type of work, is to really explore whether someone with DACA has different options now. For example, if you have had DACA and you traveled on advanced parole and now you're married to a US citizen, there could be an option for adjusting your status here in the United States. Now, again, I don't want to, I'm not talking about a specific case, but making a general point that people's lives change, and often that could be to their benefit. So it's extremely important that folks can go see an immigration attorney to see if their lives have changed to the point that their immigration cases have changed. When the original DACA was introduced, there were about 14% of DACA recipients that qualified for something more permanent, but just hadn't explored that opportunity. Either that was because of lack of funds, they couldn't pay an attorney, or they just didn't know an attorney. And so it's extremely important to actually explore all those avenues and talk to someone about what their possibilities could be. Because unfortunately, if the program, like I said, it ends, and it has gone through the entire legal process and is done the right way, then I think people could be going back to undocumented status.
So we're glad that more questions are coming in the chat window. This is for either Kara or Raul. What is the current status for Central America TPS recipients?
Kara, I don't know if you have any more information on this, but my understanding is that certain countries were automatically extended for TPS. So Honduras, for example, even though it was announced that the program was going to end, they received an automatic 18-month extension of that program. So yeah, there's just been some movement on those programs. But again, there was a bill introduced to protect those folks so that if the Trump administration decides to end the program again, those folks could actually benefit from a pathway to citizenship.
I believe that's all the questions for tonight.
Well, thank you all so much. Kara, thank you so much for joining us today. Thank you, everyone. Like I said, please, please, please talk to an attorney about your case. It's extremely important, and reach out to us if we can be of assistance. Thank you all so much.
Thank you.
Good night, everyone.